Welcome to Legal on Demand, powered by Maguire Legal. Conversations on law, business, and the decisions that matter. I'm Sonia.
And I'm Edda. In this episode, we're talking about something that comes up more often than most employers expect: social media. Specifically, when an employee posts something online and the question becomes, can we actually do anything about that?
And more importantly, how do you manage that risk in a way that will actually stand up if it's charged? Because that's where we're seeing real exposure for employers.
Keep listening to learn, can I post this? Social media used to sit outside the workplace. That's not really the case anymore.
Not at all. The line between personal and professional conduct has blurred. Employees are posting in their personal capacity, but the impact often flows directly into the workplace, whether that's reputational damage, client concerns, or internal disruption.
And that's where employers need to be careful, because just because something happens outside work doesn't mean it's irrelevant.
Exactly. The starting point comes from Rose and Telstra Corporation, which set out when out-of-hours conduct can justify disciplinary action. That conduct must have sufficient connection to the employment. For example, where it is likely to cause serious damage to the employment relationship, damages the employer's interest, is incompatible with the employee's duties, or indicates a repudiation of the employment contract.
So it's not about controlling everything an employee does outside work. It's about whether the conduct genuinely impacts the employment relationship. And social media is where we most commonly see that connection play out in practice. And just another note before we do move on, all of the cases we mention in this episode will have their full citations hyperlinked in the show notes, so you can read the reasoning if that interests you. Okay, so how have we actually seen this play out, specifically in social media cases?
The Fair Work Commission has dealt with this consistently. In O'Keefe and Williams' Muir, Facebook comments that were offensive and publicly accessible were found to justify dismissal. And we've also seen this reinforced at a higher level in Comcare and Banerji, when the High Court confirmed that employers can take action in relation to the employee's social media activity where it is inconsistent with their duties or undermines the employment relationship.
Just to give a better understanding of how not to use social media, in O'Keefe, the applicant was found to have posted on their public Facebook page that he, quote, wonders how the work can be so useless and mess up my pay again. Cuts are going down tomorrow. And in the Comcare case, the employee began broadcasting tweets under an anonymous Twitter, now X handle, more than 9,000 to be exact, variously critical of the department, other employees of the department, departmental policies and administration, government and opposition immigration policies, and government and opposition members of parliament. It was found that, quote, some of the tweets are reasonably characterized as intemperate, even vituperative, in mounting personal attacks on government and opposition figures. 9,000 tweets is also commitment, just not the kind employers are looking for. So even where the conduct happens outside work or even anonymously, it can still have consequences.
So it's not that social media is off limits, it's that the context really matters. And that's reinforced again in Little and Credit Corp Group, where dismissal was upheld because the employee's conduct was inconsistent with the employer's policies.
Enter Lattouf and the ABC. This is where this gets even more complex. In this case, Lattouf, who is of Lebanese national extraction, was employed by ABC for a one-week hosting gig for a prominent radio program. During this period, she reposted a social media post by Human Rights Watch concerning Israel's military campaign in Gaza. She was then dismissed on the back of that, where the ABC alleged that she had failed to follow a direction, namely advice, note, not a reasonable and lawful direction, from her manager to avoid posting controversial material related to the Israel-Gaza conflict, and an alleged breach of ABC's policies.
That case really highlights the shift. It's not just about whether the conduct is inappropriate, it's about how and why the employer responds.
And that brings in general protections risk.
Exactly. Under Section 340 of the Fair Work Act, an employer cannot take adverse action for a prohibited reason, including political opinion or exercising a workplace right.
So even if the post creates reputational risk, the employer still needs to be careful about the reason for any action taken.
Yes, and this is where Section 361 becomes critical, the reverse onus. If an employee alleges a prohibited reason, the employer has to prove that wasn't the reason.
Which is where we often see employers come unstuck. The High Court in Board of Bendigo Regional Institute of TAFE and Barclay made it clear that the focus is on the actual reasons, the substantial and operative factor of the decision maker. So it's not enough to say the outcome was justified. The reasoning has to be lawful and defensible. This is where social media policies become critical, don't they?
They do, but only if they're drafted properly. A policy needs to be clear about what conduct is expected and what is prohibited. It also needs to be reasonable and connected to legitimate business interests, like protecting reputation, maintaining confidentiality, and preserving workplace relationships.
Because a vague policy doesn't really help when you need to rely on it.
Exactly. A statement like, "don't bring the company into disrepute," on its own is often too broad. What works better is a policy that explains the risk, gives examples, and clearly links the conduct back to the employment obligations. And enforcement is just as important as drafting.
Absolutely. Even a well-drafted policy won't assist if it's applied inconsistently. Under Section 387 of the Fair Work Act, the Commission will look at whether there was a valid reason for dismissal, whether the employee was notified, given an opportunity to respond, and whether the response was proportionate.
So this becomes both a policy issue and a process issue. The strongest position for employers is where the policy is clear, the conduct falls within it, and the response is measured and consistent.
From a practical perspective, what should employers be doing now?
Reviewing the policies with current case law in mind, making sure that policies reflect how social media actually operates today and not how it did 5 years ago. And just as importantly, ensuring that the decision makers understand how to apply those policies in a way that aligns with the Fair Work Act.
Because the real risk isn't just the post itself, it's how the employer responds to it. That's what ultimately gets tested. The key takeaway is that social media policies need to be more than just a document. They need to be clear, practical, and enforceable, and grounded in lawful decision-making, particularly given the general protections framework.
And if you'd like support reviewing or updating your workplace policies, you can contact us via our website. Follow Legal On Demand for more conversations on employment and commercial law.
Thanks for joining us on Legal On Demand, practical law, real decisions on demand.